So, the Supreme Court just issued an 8-1 emergency order permanently changing the Second Amendment preservation fight forever. And what's happening behind the scenes is absolutely shocking. Before we get into this, hit that subscribe button right now, because this case is still developing. Let's break down what just happened. The 8-1 vote that nobody saw coming. When 8 Supreme Court justices agree on anything in today's political climate, you know something significant just happened. This wasn't a standard procedural denial where the court simply passes on a case without explanation. This was a coordinated decision where justices across the entire ideological spectrum, from the most conservative to the most liberal members, came together to send a unified message about Second Amendment preservation acts. The only justice willing to stand alone was Clarence Thomas, who has consistently been the most protective voice for gun rights on the bench. The statistical reality is sobering. In the past decade, only 12% of emergency applications to the Supreme Court result in an 8-1 alignment, making this order exceptionally rare. What makes this even more striking is that this level of consensus crosses ideological lines that normally divide the court on gun rights issues, signaling that Missouri's approach crossed a constitutional line that even the most conservative justices weren't willing to defend. This unified stance from the court sends a clear message to other states that are considering similar legislation. Think twice before going down this path. What Second Amendment preservation acts really mean. Here's what most coverage gets wrong about SAPA laws. They're not just symbolic political statements from red states trying to make a point. These are comprehensive legal frameworks that fundamentally restructure how federal gun laws get enforced within state borders, and they have real teeth. Missouri's version, passed in 2021, went further than almost any other state by creating a private right of action, allowing any citizen to sue state officials for up to $50,000 if those officials assist federal agents. In practical terms, this means that if a federal agent wanted to enforce a law Missouri deemed unconstitutional, they would have to do it entirely alone, without any state resources, state databases, state forensic labs, or even state roads if Missouri decided to push it that far. The ATF employs only about 5,000 agents nationwide to cover 330 million Americans, which means they physically cannot enforce federal firearms laws without state help. If Missouri's SAPA law went into full effect, federal gun law enforcement in the state would essentially collapse overnight, creating a constitutional crisis about whether federal laws can actually be enforced when states actively resist. The law covers everything from federal regulations on suppressors and short-barreled rifles to potential future bans on semi-automatic weapons and magazine capacity restrictions, making it one of the most comprehensive state-level challenges to federal gun authority ever attempted. The constitutional collision nobody wants to resolve. The legal showdown at the heart of this case involves 2 constitutional principles that are on a direct collision course, and neither side wants to admit there's no clean answer. On one hand, you have the Supremacy Clause of Article 6, which clearly states that federal law is the supreme law of the land, and that state judges are bound by it, regardless of what state constitutions or laws say. On the other hand, you have the anti-commandeering doctrine, which says that while federal law is supreme, the federal government cannot force state officials to enforce federal programs or regulations. This principle was established in the 1842 case Prigg versus Pennsylvania, and was dramatically strengthened in the 1990s with cases like Prince versus United States. The problem is that the Supreme Court has never definitively resolved what happens when these 2 principles directly contradict each other, leaving lower courts to make inconsistent rulings based on their own interpretation. Missouri's law sits right in the middle of this unresolved constitutional tension, forcing courts to choose between federal supremacy and state sovereignty in ways that have massive implications beyond just gun rights. The Eighth Circuit's decision to strike down Missouri's law essentially said that anti-commandeering principles don't apply when states use them to protect Second Amendment rights, creating a content-based exception that has no foundation in Supreme Court precedent. So, here's my question for you. Do Do you think states should be able to refuse cooperation with federal laws they believe are unconstitutional? Or does that road lead to chaos? Drop your thoughts in the comments below, because this is the debate that's really at the heart of this entire case. Why this emergency order rewrites the playbook. The Supreme Court's decision to deny emergency relief in this case doesn't just affect Missouri. It creates a roadmap that will govern how every future Second Amendment Preservation Act case gets handled for decades to come. When the court denies emergency relief, they're essentially saying that the legal questions aren't clear enough or urgent enough to warrant immediate intervention, which sends a powerful signal to lower courts that they have permission to keep blocking these laws. The practical effect is that even if Missouri eventually wins on the merits after years of litigation, the law will have been blocked the entire time, making the victory largely symbolic. What makes this order particularly significant is the timing. It came down just weeks before several other states were planning to introduce their own SAPA legislation in 2025 legislative sessions. Those state legislators are now looking at Missouri's experience and realizing that even if they pass a SAPA law, it will immediately be tied up in federal court and blocked by an injunction for 5 to 10 years. The chilling effect on state-level Second Amendment legislation is already visible, with at least 3 states quietly shelving their planned SAPA bills after seeing what happened to Missouri. Kansas, which passed a SAPA law in 2013, has watched its law remain almost entirely unenforceable, and Wyoming strengthened its SAPA provisions in 2022, only to see state officials too scared to actually invoke them. The 23 states watching every move. What most people don't realize is that 23 states filed amicus briefs supporting Missouri's position in this case, representing nearly half of all American states and over 145 million people. These weren't just red states making a political statement. The coalition included purple states and even some blue-leaning states concerned about federal overreach. The geographic distribution is striking. Every state west of the Mississippi River, except California, Oregon, and Washington, signed onto briefs supporting Missouri's right to pass SAPA legislation. What unified them wasn't necessarily agreement with Missouri's specific law, but rather deep concern about the precedent being set for federal power over state policy choices. States spend approximately $4.7 billion annually on law enforcement activities that support federal priorities, and if the federal government can force cooperation on gun laws, what stops them from forcing cooperation on immigration, drug enforcement, or any other federal program? The implications of this case extend far beyond firearms into fundamental questions about federalism and state sovereignty that affect everything from healthcare to environmental regulation. Montana's Democratic governor actually supported the state's amicus brief, stating that federal overreach threatens state sovereignty regardless of which party controls Washington, showing this isn't just a partisan issue. The Supreme Court's 8-1 denial effectively told all 23 of these states that their concerns about federal overreach don't outweigh the constitutional problems with Missouri's specific approach to SAPA legislation. What Justice Thomas's lone dissent tells us. Justice Clarence Thomas, standing alone in this case, is far more significant than it might appear at first glance, because Thomas has become the Supreme Court's most consistent originalist voice, and his solo dissents often become majority opinions years later. Thomas has dissented alone in major cases 41 times during his tenure on the court, and in 7 of those cases, the court later reversed course and adopted positions aligned with his original dissent. His most famous solo dissent came in the 2005 case Kelo v. City of New London regarding eminent domain, where he argued that the majority's interpretation would harm property rights. That decision became so unpopular that 45 states passed laws limiting eminent domain in response, essentially vindicating Thomas's position. His willingness to stand alone in Missouri's SAPA case suggests he sees fundamental constitutional principles at stake that go beyond the specific issue of gun rights. Thomas's judicial philosophy on the Second Amendment is the most protective on the court, rooted in his belief that the amendment protects an individual right that predates the Constitution itself and cannot be significantly restricted by government at any level. In the 2022 Bruin decision, Thomas wrote for the majority that gun laws must be consistent with historical tradition, creating what many scholars called the most protective Second Amendment standard in American history. Yet he was the only justice willing to grant Missouri's emergency request. The fact that even Justices Alito, Gorsuch, Kavanaugh, and Barrett, all strong supporters of gun rights, voted against Missouri tells us that the law crossed a line that even the most conservative members of the court weren't comfortable defending. What do you think? Was Justice Thomas right to stand alone? Or did Missouri's law actually go too far in trying to obstruct federal authority? Let me know in the comments, because this gets at fundamental questions about how our federal system should work. The Trump administration's contradictory position. Here's where this case gets genuinely bizarre. The Trump administration argued to the Supreme Court that Missouri's SAPA law is largely unconstitutional and should remain blocked, while simultaneously promising that if the court denied review, they would release most of the injunction and let parts of the law go into effect. This isn't a nuanced legal position, it's a logical contradiction that reveals deep confusion or disagreement within the administration about how to handle state gun rights laws. On one hand, Trump positioned himself during the 2024 campaign as the most pro-Second Amendment president in history, promising to protect gun rights from federal overreach. On the other hand, his Justice Department is actively arguing in court that states have no power to interfere with federal gun law enforcement. The promise to narrow the injunction was made months ago, but the Trump Justice Department still hasn't filed any motion to modify or dissolve it, creating enormous frustration among gun rights advocates who feel they were played. Some legal observers believe the administration is facing internal disagreement about how to narrow the injunction without creating precedent that could be used against federal enforcement in other contexts like immigration or drug laws. The career attorneys at the Justice Department's Civil Division, who are largely the same people who worked under Biden, continue to defend federal power, while Trump's political appointees face pressure from gun rights groups demanding action. Missouri's Attorney General has started making public statements questioning whether the administration will honor its commitment. But there's no legal mechanism to force the federal government to file a motion it doesn't want to file. What actually happens in the lower courts now? The case is now officially back in the hands of the U.S. District Court for the Western District of Missouri, where Judge Brian Wimes, a Biden appointee, originally struck down the entire SAPA law and issued the preliminary injunction that's been in place since 2022. Judge Wimes made it very clear in his original 74-page opinion that he believes SAPA laws are constitutionally problematic and represent an impermissible attempt by states to nullify federal law. His ruling was comprehensive and showed little sympathy for Missouri's federalism arguments, stating that while states can choose not to participate in federal programs, they cannot actively create penalties for state officials who do choose to cooperate with federal agents. The procedural pathway from here gets complicated because the case hasn't actually gone to a full trial on the merits yet. Everything so far has been on preliminary injunction and appeals of that preliminary injunction. Missouri is entitled to a full trial where they can present evidence about how the SAPA law operates in practice, call expert witnesses on federalism and constitutional law, and make a complete record for appeals that could take another 3 to 5 years before final resolution. The question now is whether Judge Wimes will even allow the federal government to voluntarily narrow an injunction he believes is necessary to prevent constitutional violations, as federal judges have substantial discretion over their own injunctions. At trial, Missouri will have the opportunity to present detailed evidence about how federal gun law enforcement actually works and what the practical effects of the SAPA law would be, while the federal government will argue how SAPA laws interfere with critical law enforcement operations and endanger public safety. the national implications for gun rights going forward. This Supreme Court decision creates a critical precedent that will affect gun rights litigation nationwide for the next generation. And the implications go far beyond just SAPA laws. What the court has effectively said with this 8-to-1 denial is that states cannot use anti-commandeering principles to actively obstruct federal gun law enforcement, even if those states believe the federal laws violate the Second Amendment. This closes off what many gun rights advocates saw as one of the most promising strategies for protecting gun rights at the state level. The practical effect is that gun rights will increasingly be determined by national politics and Supreme Court doctrine rather than state-level resistance. The future of gun rights litigation will likely shift back to direct constitutional challenges to specific federal laws, trying to get courts to strike down individual regulations as violating the Second Amendment under the Bruin historical tradition test. This is a slower, more expensive, and less comprehensive approach, because each regulation has to be challenged separately through years of litigation, with gun rights organizations needing to fund massive federal litigation campaigns that cost millions per case, instead of relatively inexpensive state legislation. If Democrats ever regain unified control of the federal government and pass comprehensive gun control measures, states will have no ability to refuse cooperation with enforcement, as the Supreme Court has now signaled that gun sanctuaries aren't constitutionally permissible in the same way immigration sanctuaries have been upheld. The long-term trajectory of Second Amendment protection in America may hinge on what happens with this Missouri case in the next few years, and whether the Trump administration actually follows through on its promise to narrow the injunction. So here's my final question for you. If states can't use laws like SAPA to protect gun rights, what strategies should gun rights advocates focus on instead, or is this fight already lost at the state level? Drop your thoughts below, because the future of Second Amendment protection may depend on figuring out the answer. That's everything happening right now with this critical Supreme Court order and Missouri's Second Amendment preservation fight. If you found this breakdown valuable, smash that like button and subscribe so you don't miss updates as this case develops. Drop your thoughts in the comments below, and remember, stay informed, stay armed, stay free.